Good morning, Barb Teachblade Reynolds here, blog author of Paralegal Brain, the blog, and owner of Tehachapi Court Services. I was asked by a young lawyer to draft a complaint, no, an answer to a complaint. Very interesting fact pattern, and wanted to talk to you about it. Um, and the concept that I used for 30 years in teaching how to answer a complaint or how to formulate a complaint, and that is clusters of areas of the law. Uh, what does the complaint sound like? What does the answer to the complaint have to sound like? And sounding by that I mean what areas of law impinge upon that fact pattern. For instance, in this particular fact pattern, the areas of law that it sounds in is civil procedure, it sounds in real property, it sounds in contract law, and it sounds in criminal law. A few facts. Uh, this couple has a house, and they claim they never sold their house. And the plaintiff claims that two people presented themselves and claimed to be the defendants. Well, the defendants did not sell their property for one half its value. Why would they do that? The house is paid for, and it's in very good condition. There certainly isn't any reason for them to sell the property at half price. So there's a real property question. It sounds in real property, therefore. The complaint was not verified, neither by an attorney nor the plaintiff. So it's a question of civil procedure, and being that the complaint was not verified, neither by an attorney nor the client, the a general denial of the complaint is what we drafted and generally denied each and every allegation of the complaint and specifically denied that any sum was owed either as specifically demanded in the complaint or otherwise. And the affirmative defenses included um, facts that sounded in contract law and sounded in criminal law. Real property as well. The real property issue was the fact that there was no writing. The writing is a requirement under the statute of frauds because anytime you sell a piece of real estate, you have to have a written contract memorializing the agreement and the purchase. And in this case, there was an attachment to the complaint uh, alleging to be this sale agreement, but it had no signatures attached. There was no signature page, and clearly no signatures of the defendants, who in that case would be the charging parties. So that was the first red flag that it sounded in real estate law because it did not have the contract, which in real property in a sale you must have a written agreement to avoid a claim of violation of the statute of frauds. There was also a question of contract law because without the signature page, the contract, the sale of the real property, that was vague and ambiguous to say the least. There was an offer, presumably there was an acceptance by the uh, plaintiff, presumably, and consideration. Well, what was the consideration to the defendants? Because why would they? sell their house for one half the value to anybody, especially if it's in good condition. They'd sell it themselves, not sell it at half the price. Anyway, there was also the issue of there not being any signatories to this so called contract, which also left it vague and ambiguous. You got to have an offer, you got to have an acceptance, you got to have adequate consideration flowing both ways to the parties to the contract, and the terms of the agreement must be definite and certain. It certainly wasn't a certainty that there was an agreed upon amount of the sale. There clearly was no certainty as to who the charging parties are to the contract because the signature page was missing. So uh, the general denial uh, to the complaint was filed with the court, and the a copy of the original complaint filed with the court was requested, and lo and behold, the signatory page was there attached to the exhibit, claiming to be the contract, and the client saw that signatory page and immediately said it was a forgery. So this is where the case sounds in criminal law, and they proceeded to contact through the young lawyer the district attorney's office, and that's where the matter is now. They did answer the complaint, but as you can see with this peculiar fact pattern, complaints and answers sound in law, and you gotta cluster those various areas of law that could impinge upon the particular fact pattern so that you can have a fairly comprehensive complaint and answer to that complaint. So the client, I didn't have to draft and answer each and every one of these allegations to the complaint because it was a general denial because the complaint was not verified, attesting as to the truth and accuracy of the complaint that was served on the defendants. If you have any questions, you be sure to reach out and give me a hoot either by text, social media. I'll be happy to answer any questions you've got, procedural questions, of course, and hope this helps. You have a great day and remember to make each day your masterpiece. Take care. Bye bye.